Americans spend hours commuting in their cars, and anytime I post a video dealing with somebody's arrest after being pulled over in their vehicle, those videos are very popular with you.
Take a close look at a new small car from today's Chevrolet, new Spectrum. In Spectrum, you'll discover both sporty performance and everyday economy. The performance comes from 5-speed overhead cam thrills that boast a test track time of 0 to 50 in 8.2 seconds. Spectrum's economy comes from the highest gas mileage of any sedan in America. Discover new Spectrum, the sporty car for everyday driving.
Drive today, Chevy. Live today, Chevy. Chevy.
I have previously discussed two Supreme Court cases, Belton and Chimel. I will link both of those videos above and will be briefly talking about them in this video, so I encourage you to watch those first. But today we're going to continue our discussion and answer the question whether the police can search your vehicle after you're being handcuffed and secured away from your car. In this video, we'll be discussing a Supreme Court case, Arizona versus Gant. And here's what happened in the case. The officers received an anonymous tip that somebody is selling narcotics out of their home. The officers arrive to the location, they knock on the front door, and Mr. Gant answers. He tells the officers that the owner of the home will arrive later. The officers leave, and they continue their investigation. They find out that Mr. Gant has a warrant for his arrest because he was driving on a suspended license. The officers then come back to the home a couple hours later. They see two individuals close by. They arrest those two people because they had narcotics on them and drug paraphernalia. Now, as they're conducting their business, they see Mr. Gant pulling up to the driveway of the same home. They recognize Mr. Gant from earlier. So then when Mr. Gant stops, he gets out of the car, closes the door. As he's approaching the officers, one of the officers recognizes him again. He now knows that Mr. Gant has a warrant for his arrest, and he himself witnessed Mr. Gant driving on a suspended license right in front of him. So the officer puts Mr. Gant in handcuffs and arrests him. Now, because of the two other people, they don't have enough space in the car to put him in the police vehicle. So they call for backup. When the backup arrives, they put Mr. Gant in that vehicle. Now that everyone is handcuffed and secured, the officers go back into Mr. Gant's vehicle and they find narcotics in the back seat of Mr. Gant's car. Now the question is, could they search Mr. Gant's vehicle without a warrant as search incident to arrest? Anytime we're discussing the Fourth Amendment, we must start with the basic rule that any searches conducted outside of the judicial process, meaning without the approval of a judge or a magistrate, are per se unreasonable. Now, in Chimel, we've learned that officers can conduct a search incident to a lawful arrest, but only two areas can be searched: the person himself and the areas in the immediate control of that person. There were two justifications for that rule. One, the safety of the officers, and two, the safeguard of any evidence that could be concealed or destroyed in the process. Now, in this case, it seems like under Chimel, Mr. Gant's car should not be searched. After all, it is no longer in the immediate control of Mr. Chimel. He's been handcuffed and secured and sitting in the patrol vehicle. So how could he possibly go back into his own vehicle? But I know what you're thinking. What about the Supreme Court case Belton, where the officer stopped the vehicle, he smelled marijuana, he saw an envelope with what he thought contained marijuana, he asked the four passengers to get out of the car, he didn't handcuff them, he just asked them to split apart. The officer then went back into the vehicle. In the back seat, he found a jacket, and inside that jacket, he found narcotics. Now, the Supreme Court then told us that that search was constitutional as search incident to a lawful arrest. The officer had enough reasonable suspicion to go inside the vehicle. So it seems like under Belton, the Supreme Court told us that the officers can always search inside the passenger compartment of the vehicle if they're conducting a lawful arrest. The Supreme Court even said that that was a bright line rule. But decades later, in this case, the Supreme Court now tells us that if we read Belton so broadly, it will swallow the rule under Chimel. So to be clear, in order for the officers to search inside the vehicle as incident to a lawful arrest, the person must be unsecured and within the reaching distance of the vehicle. And although it does not clearly follow from Chimel's opinion, the Supreme Court now tells us that if the officers are using search incident to a lawful arrest exception to a warrant, they must be searching for evidence of a crime inside the vehicle. Meaning in Belton, the officer had reasonable suspicion that he would find narcotics inside the vehicle. But in this case, Mr. Grant was driving without a license. So what's the crime? It's driving without a license. What could possibly the officers find inside the vehicle? Clearly, they're not going to find the driver's license for Mr. Gant. So after all, this search was unreasonable and unconstitutional under Chimel because after all, Mr. Gant was nowhere close to the vehicle. He was secured and inside of a patrol car. And it is not clear what exactly they were trying to find inside Mr. Gant's vehicle. If you enjoyed this video, please click like, subscribe, hit that bell notification button so next time I post, you'll be first to know.